Hello, this is Jed Brewer with the Below the Line Club and Study Groups. Very nice to talk to you today. Thank you for being on the call as we talk about family, business, succession, and ownership transfer. Succession, business continuity, wealth transfer for family businesses, which the majority of companies in the U.S. Today are huge topics. They talk about value creation, liquidity, legacy planning, all kind of things that drive succession and transfer. And today we have two experts who are going to help us muddle through these murky waters that often come with business succession. And one of the key things that we always want to focus on whenever there is a transfer or a succession plan is how do we set the business up to survive and to thrive, not just necessarily transfer dollars and cents. And I'm really pleased that Mitch Vandiver, who's the president of Strategies Inc., and one of our presenters today, that's really his approach and philosophy in working with companies to transfer the family business is let's take care of the business and make sure it's a healthy and successful company as we work through the various family issues that are involved. So the webinar today, what we're going to focus on is to gift or sell the company to the next generation. Should we or shouldn't we? Pros and cons of various types of moving ownership from one generation to the next. How do we value things? What kind of interest rates, deficits? What kind of control do we give? And what are the typical traps that many people fall into as we try to move business control or ownership, et cetera, from one generation to the next? And joining Mitch is Jennifer Pratt, who's the Vice President of Adavco Family Office. And just a brief bio before we turn it over to our presenters. But Mitch, as I mentioned, is president of Strategies Inc. He has a lot of experience in finance, and which is helpful as he works through family succession. And he's worked with a lot of founders and CEOs of family businesses over time. He's been honored as a fellow of the Family Firm Institute, and just as a veteran presenter, there's a range of topics that he can talk about, and he's worked with a lot of study group members over time. Many of you may be familiar with Mitch, may have seen him present at a study group meeting, or some of you may know other study group members that he's worked on the succession transition piece with. And Jennifer Pratt works alongside with Mitch. She's with a different company, but they often work together collaboratively. And she was recently a partner at the Tax and Wealth Planning Group. Today, she's the Vice President of Planning for a family office, and I'll allow Mitch to share a little bit more about that. But she has significant experience with businesses like ours, S corporations, family limited partnerships, limited liability companies, split interest trusts, life insurance planning, estate freeze transactions, et cetera. So very knowledgeable people that are in this field today, and we look forward to hearing what they have to share with us. So a couple quick notes before I turn it over to them. This webinar is recorded. We will send the recording out to you along with this slide deck afterwards, so you can share it with a colleague, et cetera. And then two, we want this to be as educational and collaborative as possible. So if you do have questions, please type them into the questions area of this GoToWebinar dialog box that is there. I will be able to see those questions, and I will relay them on to the speakers at an appropriate time. But we want to do our best to make sure your questions are answered. So with that preamble, Mitch, I am going to turn it over to you to talk about business succession.
Great. Thank you, Jed. So let me just get the screen share going. I want to elaborate a little bit on the intro for Jennifer Pratt. On my end, being a family business consultant, we can't do a lot of the work that we do as far as how we implement various techniques on the estate planning side without partnering with really good attorneys that understand not only that discipline, but how to apply it to family businesses. And when Jennifer originally agreed to do this, she was still at the firm that we do a lot of work with, Venable. But then she got a great opportunity to actually be part of a family office. And that family office made their fortune, and it truly is a fortune, from selling to BP many, many years ago. So the family probably has, God only knows how many trusts that are in place, et cetera, et cetera. So Jennifer not only brings the legal discipline, but the practical experience of how to really apply this in a multi-generational family business. So I want to thank her for joining me. Let me frame up today's discussion into 4 key things. 1, how do we approach succession and continuity planning in a holistic way? 2, a very timely and specific call to action because of pending tax changes that will take place relative to estate tax. At a minimum, it will happen at the end of 2025 when the current exemptions sunset, but it's actually very likely it's going to happen sooner rather than later, depending on how the election plays out. Then we're going to share 3 case studies. One being kind of a lesson of what not to do. I often think the best way to learn is to hear the mistakes and not replicate them. And how could they have approached their own wealth transfer and succession plan differently? And then an approach that says if we have a green field, in other words, we haven't really transferred any ownership yet, what type of technique works best to move wealth from one generation to the next while still being able to maintain control and flexibility and create an income stream? And the last example we'll give you is a family that had put some rudimentary plans in place, but it didn't work from an income point of view for the 2 principals. And now they're kind of trying to figure out how do I get income and still shift wealth based on planning that are already taken place. And if time permits, we'll give you a summary of a way to completely eliminate the estate tax burden through philanthropic efforts and the ability to shift that wealth to future generations. So many of you, I assume, since we've done a lot of work in the study groups and Sigma, et cetera, may have seen me speak before. And when I talk about holistic planning and continuity planning, we stress that there's 6 key things you must address. Those things specific to the current generation, their role in the company, how their role evolves over time, how they secure their own income and liquidity independent of the business so they can not only exit the role, but exit financially. How do we prepare the next generation to be both good leaders and managers of the business and or good stewards of the wealth that's been created? And how you look at where the business is in its current life cycle and its vision for the future to build the right type of management and organizational structure to enable the business continue to grow and thrive. And then typically what I say is the last thing you should be worried about is estate tax, because it's one of the easier things to actually solve technically. And it's not something that I would typically say we had to lead with. However, today we're going to go really deep into how to transfer ownership from one generation to the next and how to mitigate estate tax, because there truly is this call to action. And the estate tax is one of the things that prevents a family business from going from one generation to the next, because if we don't plan for that burden, we might have to sell the business or sell assets to fund that tax. So there's a sense of urgency. So today, I'm just going to leave you with that framework of the 6 things we should focus on, but we're going to go really deep into the tax piece and the shifting of ownership. And if I were in front of you versus a webinar, I would quiz the group and ask you to tell me what these 3 numbers mean. But we can't do that because of the format. But we have 24 million plus, almost another $9 million, $8.5 million. These 3 numbers represent the increase in the estate tax burden come the end of 2025, again, possibly much sooner based on the election. That's a huge increase in a tax, on top of a big tax to begin with. So Jennifer, I'm going to talk about how do we effectively shift assets to minimize the estate tax, but do it in a way that enables the current generation to manage to get their income that they need independent of the actual business. And why do we focus on, it's not just about gifting. Gifting is really easy. You give it away up to the exemption amount. The downside of just giving it is it doesn't produce an income stream for you. And I have too many folks that we've worked with that gave away things prematurely, gave things away in such a way that they didn't retain proper control, and trapped them in the business from an income point of view. And this 93% number is a real statistic of privately held businesses where all of the wealth and income is tied to the actual business. And if all of my income and wealth is dependent upon the business, it's really scary to talk about giving stuff away. It's really scary about stepping away from the business, because how do I know that I'm going to get the money that I need to continue to live the lifestyle that I choose, both today and the future? So all the planning that we're going to talk about is focused on making sure we still have that income stream and that we protect that. Well, I don't know about you guys. I spend a lot of time on planes, and I know your industry does a lot of traveling. And we haven't done it since March for the most part, but we spend a lot of time in airplanes. And we probably don't even listen to it anymore, but the message about secure your own oxygen first in the event that the mask comes down before you do the same for your children applies when we talk about gifting ownership from one generation to the next. I can't stress it enough that we have to secure your own liquidity and income stream prior to just gifting company assets away. And one of the exciting things is now versus back in 2012, when a lot of business owners shifted a lot of assets because of some pending changes then, the techniques now are more flexible, more robust, and give us options that we really didn't have back in 2012 and prior to that. But secure your own oxygen first. And Jennifer, I'm going to ask you to kind of address this next slide.
Sure. So thank you for the nice, kind words, Mitch, at the beginning of this. And I'm a reformed, private practice attorney. And one of the things that's really important when you look at this, like Mitch said on the prior slide, is it's really important. Everybody focuses, and all estate planners do. We all are guilty of this. There's $11,580,000 of an exemption available for each person during their lifetime. And like Mitch said, in 2012, a lot of folks and a lot of you on this call may have already done a lot of that gifting. So you might only have the additional $6 million that's available to you now, because you might have already gifted some. But people get so tunnel visioned into thinking, oh my gosh, we're going to lose this in 2026, or oh my gosh, we're going to lose this in 2021 or 2022, depending on the results of the election. So we got to rush. We've got to rush and get this done. And so, that is a huge amount of money to give away. But what it says to me, as opposed to some other folks out there maybe that are doing this planning, is that it's a huge opportunity for us to take a minute and take a deep breath and say, okay, what is it that we are looking to do? And how is the best way to position the business owner from transferring this wealth, utilizing the exemption that might go away in this call to action time frame, but in a way that secures the business owner, matriarch or patriarch's future income stream, and allows the most use and the biggest leverage of that estate GS generation skipping transfer tax exemption. So that's what we're talking about, because $11,580,000 is unprecedented. We have not had that. I've been practicing for nearly 22 years, and we just never had that large amount before. When I started, it was $675,000. That's how much you could pass. And now folks have $11,580,000. And even if the election doesn't change and we don't have, we still have a Republican Senate and a Republican president, if nothing changes, 2026, the exemption is going to decline in half, because that's when it was originally ready to sunset. But as Mitch is saying, there's this, COVID-19 has affected the economy. It has affected across the board, states and federal governments, and there's going to be a need to raise revenue. And the easiest place to do that is always on the wealthy, because, and especially in the estate taxes, because this isn't something that affects you day to day. It's something that gets paid at your death. And there's plenty of provisions already in the tax code to allow you to keep your family business. There's exceptions for the family farm. There's the 6166 election that allows you to pay it out over time at low interest rates. So there's so many things built in to allow people not to have to sell the family business, that the IRS and the government feel like this is an easy place to go, right? And if you don't have the liquidity to cover it, because you have an illiquid family operating business, you're still going to be okay, and we'll help you get through that. But for the people that are liquid or do have significant wealth, it's an easy place to go. So now we're really looking to find a way, can we shift these assets out of the estate, and how much of the asset can we shift using such favorable techniques that are built in the code already? I mean, grantor retained annuity trust, estate freezes, things like that, or sales to effective grantor trust you can take advantage of that will allow you to have an income stream, that will allow you to transfer the wealth utilizing the exemption and leveraging it, but taking care of yourself and putting your oxygen mask on first, so to speak. So Mitch, let's look at the next. Yeah.
Sure. So the next slide is really the math slide. I won't go into great detail here, but this is showing 3 companies, XYZ Food Stores, ABC Oil, and Family Holdings, that I believe are representative of companies that we see in your market from a value point of view. And if we look at the exemption combined, assuming it's a married couple, we have taxable estates ranging from 76 million down to 26 million, and estate tax liabilities ranging from 31 million down to 10. Those are big numbers to plan for. And there are ways you can hedge it through insurance, but if you didn't buy the insurance at a young age, it can become rather expensive to cash flow. But sure, insurance is part of it. Giving and using the exemption is part of it. Selling assets so we get the appreciation out of your estate into the next generation is another way. But these are real numbers. And then down at the bottom, if you take those values up top and you apply a relatively conservative compound annual growth rate to them, and then look at the sunset that's going to happen from an estate tax point of view at the end of 2025, that $30 million liability is almost $55 million. And that $10.5 million goes up to $18 million and change. That's a big increase. So Jennifer is spot on when she says, let's not just react to the tax code and do something without being very deliberate and thoughtful about, is it the right thing to do? And how do I do it in a very deliberate fashion that meets my needs and my objectives? And it's not just a good, quote unquote, tax strategy. It's a good component of an overall succession plan. So how do we kind of develop that thinking and develop that plan? We're going to walk you through 3 case studies. The first one, you can probably tell from the image, is the one where we say what not to do. And how do we learn from those mistakes? So a very wealthy family in an unrelated business, lots of real estate holdings, beautiful cash flow. Their estate planning attorney and CPA called me and said, we need your help with this family. And their plea for help was the family's not getting along, they're fighting over control, they're not spending the holidays together anymore. And then they said, but Mitch, you and Jennifer, et cetera, you don't need to address the succession plan or the estate plan because we've already done it. And they did already do it, and they did a very effective job of shifting assets from the senior or current generation down to their children. But they did it in such a way that they drove the valuations way down, and they used a particular technique that was very inflexible and lost control. And then the situation went south, and that image that you're looking at is what was going on. And the problem, or the what not to do, is when you think about family businesses, it's a system. You've got the family itself, the relationships, the parent-child, sibling to sibling, all the things that go on in that circle. You have the ownership component, how the company's owned, the structure of it, who owns what in percentages, and the management of the company. When you think about succession planning and you think about your estate plan, I encourage you to think at that intersection of those three things. Because if you just focus on the ownership and you just start shifting assets to minimize taxes, you create other problems. And what this particular family did, and unfortunately the advisors did, is they thought the right thing to do was shift everything, let's use all the gifting up possible, and then use a technique called a grantor retained annuity trust, which Jennifer will go into. But they did it equally, and they said we're going to treat all the kids equally. And the reality was one of the children could run a Fortune 100 company and was highly talented and had taken the value at the time of the gift to a much higher valuation based on his efforts. The other two siblings were really good at playing golf and really got low handicaps, but they didn't contribute to the business or the value. And this notion that equality is inherently fair, these two kind of tail wagging the dog things come to play all too often in family businesses. If we treat everybody equally, I can sleep better at night, but our contributions are different. The value that we bring to the business is different. We can still treat them equally in other ways, but when you're talking about dividing a business, think about the contribution, think about the talent, think about the desire and the drive, and don't just say equality is inherently fair, because often it's inherently unfair. And the brother that drove the value was very resentful that everybody else was participating at the same level that he was. And the last tail that wagged the dog was tax. The advisors were so proud of their Mona Lisa tax plan, and they couldn't stress enough that don't mess with the planning that already took place. The planning is what caused that black and white image of everybody fighting. It was actually the cause of it. It was the catalyst of it. They all got along before they restructured and did what they did. And then the last kind of component that created a lot of complexities is the technique that was used, which we're going to share at the next slide, was inflexible, and it didn't provide enough income for mom and dad. And it caused dad to still come into work every day to justify taking a salary when he really didn't even want to be there, but he needed the money because of the structure that they used. And two, he wanted to unwind it when he saw it didn't work, and he couldn't because of the tax, because of the technique that was used. They were actually trapped, and they couldn't figure out how to fix this. And the technique that was used, the acronym is a GRAT, okay? We'll try to minimize the estate tax lingo, but the grantor retained annuity trust was what they ultimately used. And there is a use for this, and there is a right way to do this, but it has limitations. So Jennifer, I'm going to ask you to go a little bit deeper into this slide as well as the next one.
So looking at this slide, I'm going to focus your attention to everything on the left, where we start with the business owner and the GRAT and the children. And I want you for a minute to ignore everything on the right-hand side, because in the situation that Mitch is talking about, they did what we call simple GRAT. What you do, the business owner puts in the asset, stock, percentage of stock, all the stock, some percentage of stock or interest in the LLC into the GRAT. It's a grantor retained annuity trust. What that means is exactly what it says. The grantor, who's the business owner, is retaining an annuity stream of income for a period of years, and then whatever's left over after that period of years is passed to the children, that remainder interest. So the business owner transfers that stock. Now, estate planners, we're all looking for low values because we want to maximize your exemption use. So here, you take a business and you want to discount it, lack of marketability, lack of control if you're not giving a controlling interest away. And so you purposely are giving away usually less than 50%, or you're setting up 3 of these, maybe in different categories so that you can discount it for different reasons. And if you have 3 children, like Mitch is saying, you might set up 3 separate GRATs. But you get the annuity back is to give you back what you put in, the value of what you put in, plus what is the 75/20 rate that the IRS says is the minimum you need to beat. Now, the 75/20 rate currently is like 0.46%. It's very low. So generally, your operating business is going to be able to produce a return that is higher than 0.46%. At the time that you did this, the rate might have been a little higher, maybe a little lower, but the rates have been really on a downward trend for a bit, and they're at historic lows right now. So the business owner puts this in, takes this back, but because they kept pushing the values down, the income stream for the term of years was low. And so they get back enough money to make it so that the GRAT works for purposes of the IRS estate shifting, and we're able to shift all those assets to the children. But the GRAT is an irrevocable trust. And when it goes to the children, it's done. You can't get it back out. So you got back this small income stream for a term of years. And generally, you want to set that term to be short if you can, because the mortality risk is involved. If the business owner dies during the term of that GRAT, the assets are included in that business owner's estate for estate tax purposes, and then your GRAT didn't work, right? So we try not to have long-term GRATs, and so you try to set these at 5, 7 years, maybe 10 at most, if you're not doing anything more exciting or more sophisticated when you're planning. Just setting up a straight standard GRAT, you're looking at low valuations, shorter terms, and now the money, the business interest, and of course all the distributions on the business, right, are going to go to your children after, say, 8, maybe 10 years at most. Now what happens? Just like Mitch said, dad is coming into work, I got to pay him the salary, and everybody at the office is confused. Do I take my direction from dad? Do I take my direction from one brother, the one son who's there all the time, or the two that jump in when they get off the golf course? Who's really in charge? Because this whole thing doesn't always work as well. And we estate planners love this technique because it's blessed in the code. In the Internal Revenue Code, it sets out we're allowed to do this. It tells us exactly how to do it. You follow the terms of the Internal Revenue Code, check the boxes, it's done, it's great, it's a great technique. But when you don't do what Mitch said at the beginning, when you don't stop to think about, well, what does the business owner need? What's the exit strategy? What makes the most sense for the family overall? You institute something that can be very well done, but maybe this is the wrong asset or the wrong family or the wrong technique to use in this particular case. Now, Mitch, if we look at the next slide, we can talk a little more about specifically what grantor retained annuity trusts are beneficial for, right? So generally, you're going to get a gift when you form these, because like I said, the grantor has to take back what he put in plus the 75/20 rate, which we talked about as 0.46. And it's a very small, you take that principal back plus that 75/20 rate, whatever the IRS calculates based on the dollars that you put in and the annuity payout you have to take back out over the plus the term, that amount will be a taxable gift. You can push this a little longer so that you give more back to the business owner if you want to zero out the GRAT. Generally, you wouldn't do that when you're talking about an operating business that you're trying to use the GRAT technique as a way to transfer. I generally will see zeroed out GRATs when I'm using marketable securities. And they work very well for short-term transfers of wealth on marketable securities. If you think about it, when you have marketable securities, you do a short-term 2-year GRAT, you zero it out, you should, even if you do a 3-year GRAT, your financial planner, your investment advisor should be able to beat 0.46%. The market is really strong, has been really strong for a bit now, and anybody could probably beat the 4.46%. So they work, zeroed out GRATs work really well in that context, but it doesn't work really well if you're trying to transfer wealth. Now, if they had done a zeroed out GRAT in the case that Mitch is talking about, the business owner would have gotten a lot of that stock back. We wouldn't have been in the situation we were in, where dad's unhappy because he's not getting any of the distributions from the business and he can't really afford to live. You disclose this on a gift tax return. It's a grantor trust, so income tax, it doesn't make any difference, right? That's the other thing. If it's in the GRAT during the term of the GRAT, dad getting the income from the annuity payment, but it's going to get it pays all the tax on the income of the trust. So if you have a pass-through entity that's passing out that income, it's coming out and dad's paying the tax on top of that. But let's just make the numbers easy. Let's say he gets $1,000 for his annuity payment, but he's picking up $5,000 in income tax every year. So now we're making dad even poorer, right? Because now he's got to dip into his pocket to pay the income tax on the other $4,000 that he didn't get. Mortality risk that we talked about, if you die during the term, the assets are included back in your estate. You can't do any GST exemption planning, which is why on the previous slide I told you for that purpose, ignore everything on the right-hand side. There's more sophisticated planning we can do and should have been done in their case to allow for greater GST planning, which is called generation skipping transfer tax planning, so that grandfather could pass assets to grandchildren and skip the children's generation. If you do that, you have a certain amount of exemption, which is the exact same. Right now, currently $11,580,000 per person. So you can pass that to your grandchildren. But if you just do a standard GRAT, you're not allowed to allocate that $11,580,000 of generation skipping transfer tax exemption until what the IRS calls the estate tax inclusion period closes. What is the estate tax inclusion period, you ask me? It's that mortality risk. It's that term of years in which the grantor could die and the assets could revert back into the grantor's estate. During that period, which is the term of the GRAT, you are not permitted to allocate generation skipping transfer tax exemption. So the first opportunity that dad or business owner, grandfather, is able to allocate exemption is at the end of the term. Well, we certainly hope all of your businesses are increasing over the 5, 7, or 10-year term, such that by the time that the estate tax inclusion period expires, end of the GRAT term, you are then allocating generation skipping transfer tax exemption to it. It's much higher. We're not getting to leverage, right? We're using a lot more of our exemption to shelter that. So that's why you really don't use GRAT, a standard traditional GRAT, in this way. You can do a lot more sophisticated planning to allow you to do it, but that wasn't done in our case of what not to do. Depreciation is outside of the estate, but only if the grantor survives the term, and you do not get the step-up in basis of death, which is, again, something else right now for a lot of us to be focusing on. I think the big shift in the last 5 years has been income tax planning. So our estate planning mentality for all of us estate planners out there, and you probably hear this from your advisors, is, oh my gosh, the exemption's going away, let's gift, let's gift, let's gift. Well, all those gifts get a carryover basis. So you don't get the step up in basis at death. So if you have low basis assets, which typically are the case for your operating businesses that you've built from the beginning, you have those low basis assets, then your children, your descendants, whoever you're giving them to, will have that same basis at death. So you lose that step up in basis unless the grantor dies during the term like we talked about, then the assets are back included in the estate. And there's no flexibility. These are irrevocable trusts. Can't own life insurance. We can't maintain control. Everything goes. When the term is up, it's up. We can't make any changes to it. It's gone, and now it's out of your estate and into the hands of your children generally. And now you've lost any opportunity to have any more flexibility with regard to that plan.
So Jennifer, are you going into the details on the GRAT here because a lot of estate planners are sort of directing clients there today to use one of these vehicles?
Yes, GRATs are very popular, and a lot of people like to use them. And in our case, we've seen the downside to them. I love them. I mean, like I said, they work really well for specific assets. But sometimes they are not your best choice when you're trying to transfer the operating business. Sometimes they are, but sometimes they are not. And so I think that's part of it. A lot of people may hear, well, we can do this, we're going to be able to set these up, and they try to kind of do a one-size-fits-all across the board. And some assets are better set up to be transferred through a GRAT, and some are not. So that's why we're talking about them, because they do have a good place and they can be really successful, but they require a little more sophistication than sometimes estate planners are willing to look at. And because of the inflexibility of them and the loss of the step-up basis, you want to take another look at what assets you're going to fund them with.
And one of the other points I would make, Chad and Jennifer, a GRAT is a very effective technique. It doesn't check enough boxes with the word yes versus no that some other techniques that we're going to talk about do. So the GRAT can work. One of the big drawbacks, in my opinion, as a family business consultant, specific to the business itself, is it's not a form of governance. It's just a technique for moving an asset from here to there. It doesn't address all the governance needs that we need to have in a business to enable it to shift successfully from one generation to the next that may have multiple shareholders. So that image I showed you a minute ago, when we got involved and we asked for governance documents, there wasn't anything. There wasn't anything around dispute resolution. One of the brothers, frankly, wanted to be bought out of the business. They didn't have puts and calls that were well thought through. So they missed a lot of things. And then to go back and fix them, Dad had been effectively neutered because he had given up control. And his moral authority was not something the kids were listening to either. So it's a good technique. One size does not fit all. And the danger is all advisors, ourselves included, sometimes get wedded to a particular technique. I just challenge the consumer, the folks on the other end of this webinar, to challenge the thinking and say, let's talk about all the various options and which one ultimately checks more boxes in the yes category than no. With that, I'm going to shift. Is that okay, Jennifer?
Yep, no, that's perfect. And it's the perfect segue to the next case study.
So the next case study, yes, it's the Kennedy family. It's just a good image, okay? But let's assume they're a family business and there are clear roles for everybody in the family. They get along. It's a beautiful family. It fits the Camelot image. When we see a family like this and they have not done any planning, there are some other techniques that provide a lot more options and a lot more flexibility. So in this particular case study, somebody approaches us and Jennifer and says, we want to figure out how to bring the next generation into the business, both from a management point of view as well as from an ownership point of view. One, I'm not quite sure how to do that and how to do it in a very deliberate and thoughtful way, because I want to be in front of future problems. So let's work through some of those things before we're actually confronting them around governance. Two, all of my income comes from the operating business. Most business owners feel very comfortable in getting a good return on something they control. They typically are very balance sheet light when it comes to assets outside of the business because they can't control this. They don't trust the stock market. They don't trust other investments. And this particular owner is saying, I need to secure my own income at the same time. And how do I have the flexibility to change things? Because we're just entering the succession process. And as you know, it doesn't always work out the way you envisioned. Maybe somebody gets disenfranchised with the business. Maybe they're not effective. Maybe there's dispute among siblings and fights over control. If you use a GRAT, you've effectively given up control. If you use another technique, as you get further into the process, you can change things. You can amend things with a lot more flexibility. So when there's a green field, and primarily this particular technique works best when control is concentrated. In other words, it's not like a sibling partnership. It's either mom and dad or patriarch or matriarch have complete control over the company and no other planning has taken place. we like to typically use what's called a freeze plan or a freeze structure. And the beautiful thing about a freeze plan is it gives you complete control through a general manager provision. You can change the plan, you can amend the plan, you can go sell the company because things change or opportunities present themselves. You can appoint your successor in advance. So the control mechanism is huge. And I don't know too many business owners that don't love holding on to control for as long as they possibly can. In addition, a freeze plan has built-in governance. This is a business transaction first that solves estate tax versus an estate tax technique that does not address the business. So all the governance around how we're going to make decisions, if somebody wants out of the business, if somebody needs to be taken out of the business because they're disruptive, all the governance is already built into this particular technique. Third, you continue to have access to wealth. So let's say I'm the person, I'm dad, and I set this freeze plan up. In the future, I can borrow money, I can do all kinds of different things to continue to have flexibility to get additional wealth if I need to. It's an outstanding tax strategy. And Jennifer, if I'm wrong, correct me, but it's a great tax strategy for estate tax planning because we're shifting assets and the growth from one generation to the next. But it's also a very effective income tax plan as well. And we get the step up in basis, and it's just a good tax strategy. And due to the legal structure of this, again, this is really a business reorganization first and foremost that solves estate tax versus an estate tax plan first. The asset protection is huge from unintended creditor risk, whether that's a spousal event, whether it's a bankruptcy, or whether it's a tragic accident. It's very solid from an asset protection point of view. And if I have to highlight the two things that I continue to love about this, it's control and flexibility, flexibility and control. I can amend this, I can change it over time. So let us walk you through an example. Here is a typical oil company that we see. They've got the oil in one business, they've got transport in a separate business, and they've got their real estate in another bucket. Very, very typical setup. Well, what is one of the things we want to do when it comes to succession planning and transferring wealth? If we can freeze the value and know that value, it makes it much easier to plan for the estate tax because it's a known number and it's fixed. So in this particular structure, we create what we often in shorthand call NewCo. So we create a new LLC, Smith Family LLC, and we get a valuation done. And I'm going to touch on the valuation a little bit more. Jennifer talked about it earlier. There's a push and pull in the valuation process that typically the valuation firm and the CPA and estate planners are trying to get the lowest number possible because it allows you to use as much of the gift exemption as possible by shifting his assets. So it's because the value really, really low. Well, the downside to a low value is it might not produce enough income for mom and dad. So that valuation process, there's science and there's art, and all too often in the ones we're partnering together on, there's this push and pull. So in this particular example, you get the valuation back, maybe the valuation comes in at a higher number, that's great for the income stream, but maybe the company can't afford it. There's some back and forth with how you set the value. It still has to pass, the reasonableness test, but there is a subjective part to ultimately nailing that number. But in this particular case, we freeze the value of the business at $30 million, and there's a holding company where the current generation are the shareholders, and they get a preferred return off of that valuation, and that rate, probably lower now in the last couple of months, but it ranges anywhere between 5 to 7%, which is a much better return than 0.46 in the GRAT. And that can range in this $30 million example anywhere between $1.5 million to $2 million annually. In addition, the flexibility of the plan allows dad and mom as the general manager in this particular example, if the business is having a bad year, they can defer those payments for up to 8 years. So a lot of flexibility. They can create a note structure if they want to. They can gift their preferred interest to their children if they want to, once they realize that maybe they have more income than they need. Just immense, immense flexibility. And the freeze nature of this is saying that $30 million is frozen. That is part of the estate for dad and mom, but we now know the number. So maybe we can insure a part of it. We can create a sinking fund to fund part of it. But all that future growth shifts over into that blue oval called Smith Descendants for the benefit of their children. And in this particular example, it's 3 kids. And we set this up as a generation skipping trust. So we've not only solved the estate tax dilemma for the current generation, but for future generations and future generations. So by way of example, let's say the company grows from the $30 million to $45 million. That's $15 million. That value increase has shifted up to Descendants LLC. It's outside of mom and dad's estate, and the wealth is growing there for the next generation. And in this particular example, we have 3 children of the next generation. But the other nice thing about the freeze plan, as plans shift over time, this is, in this example, 1/3, 1/3, 1/3. Remember earlier, I talked about that family that didn't get along, and part of it was because they treated everybody equally. One of the things you can do is, let's say you fast forward 5 years from now, and child number 3 is the only one in the company, and they've taken that value from $30 million up to $55 million. And you feel that the other 2 children have been adequately provided for and their other assets outside of the business, you can create another freeze and say from that $45 million up, we're going to have that inure 50% to the son or daughter that's running the business because they're really driving that value. With the grants, you can't do that. With a lot of other structures, you can't do that. So you can shift it over time, which I think is beautiful. Again, we've got control, flexibility. It's a good income and estate tax strategy, and it's got built-in governance structures. So Jennifer, I want to turn this slide back over to you to go into a little bit more detail about the freeze.
So when you're looking at this freeze plan, the big thing to realize is that the only thing, there's no gift in that plan originally because each side, so mom and dad have transferred their interest into the Freeze LLC and taken back the preferred return, and then the Smith Descendants LLC would contribute usually around 10% in to cover their interest. Now, the only way you would have a gift, and you may need to have a gift, is if the children or trust for the children don't have any assets already. So a lot of times, because of 2012, at this point in the game, a lot of my clients will have dynasty trusts that do have some cash in it that they can contribute their interest in, so you don't have to do a gift, but you could make it part of your formation. So you have to have enough exemption if you don't have the children in their own ability to put money in or trust for the kids or grandkids to put money in. There could be part of it as a gift. So that's the first part. The interest rate, so this is a much better deal, like Mitch said. Instead of looking at the 0.46% or very low GRAP payout, this is a real priority return. It's a real rate of return on your money, and it really provides you with an income stream anywhere between 5 and 10%. And when you look at that, you think, okay, well, am I going to bootstrap the company, right? Like, am I going to have this payout to myself going to affect the company? No, because again, like Mitch said, there's a lot of flexibility. You can defer it for 8 years, which also allows it to build up, right? So that you can get the use of it. Maybe there's some things that you want to do in the company and you want to leave that money in so you can get some ability to allow it to grow over the next few years, because at that point, mom and dad didn't need it for whatever reason. They're doing fine. So that gives you that flexibility there. It's a partnership. And so it's a pass-through, and a lot of folks, you guys all understand this. It's a business. It's a partnership pass-through business. So it's a lot of what you've already seen with either an LLC or an S corporation or a partnership. So it's not going to be much different. There's no mortality risk because, like Mitch said, we're freezing that value And what you own is a finite number. You own the 30, in this case, Smith family, mom and dad own 50-50, the $30 million, the priority return, whatever that number is when you've done the valuation, that's what they own. And whatever they haven't been paid back on it, that's what's in their estate. So it's not a matter of the appreciation is all out of their estate because that's been done properly. It's not included in their estate. You get all of that ability to allocate GST exemption. And even though we think all the way back to that one of those first slides that Mitch showed us, looking at even just a 5-year compounding where you're going to, get all of that appreciation out, especially at a time when your exemption is going to decrease, right? So we're looking at 5 years out when we know if nothing changes with the election, I'm going to have less exemption for my clients. And this is a way for me to get that appreciation out of my estate and not have to worry that I'm going to have less exemption to cover it as it appreciates. So that's great. You get this step up in basis at death on the value of what mom and dad retained, right? So that priority return value, you'll get that step up in basis. The appreciation is all out of your estate anyway, going to the kids. So it's a different kind of a plan than like the GRAT with just a straight carryover basis. There's a lot of flexibility. Oh, go ahead.
I'm sorry, Jennifer. I'm going to speed us up a little bit because I know we only have 10 minutes left. So I'm going to shift to the next example because I think this example applies to a lot of marketers that are out there. But again, the freeze just has a lot more yeses than it does no. So Jennifer, thanks for jumping into that a little bit more. So in our next example, very typical setup. You have two families, two brothers, and between the two branches, the business is owned equally, so 50-50. And back in 2012, they shifted 40% of the value by creating voting and non-voting stock and transferred non-voting stock down to their children. And it was all done via gift. Fast forward to today, and they are coming to us and others and saying, we can't exit the business because we don't have enough money and we need to get money out of the business. It's a sub-S corporation, and since they gave shares away and didn't create either a GRAT, a freeze, or the technique that we're getting ready to talk about, they got no return for it because they just outright gifted it. So for them to do a distribution in the business, let's say they want to take $1 million out, it's many more dollars to take that $1 million out because they have to do a distribution for all the shareholders. And it's not their desire to do that, it's really their desire to protect their own income. So if you have a situation like that, where you are trying to figure out how to not only solve shifting assets from one generation to the next, but how do I get a return for it? And if I've already done some planning, it ties me up a little bit. The next technique we think is a very good one. So Jennifer, I'm going to ask you to run through that relatively quickly, I guess. Thank you. Jennifer?
Sorry, did you guys not hear me? So here, this is your intentionally defective grantor trust sale. So a lot of you probably have heard this from your advisors. A lot of people have probably seen this before. So it's like Mitch said when we talked about the freeze won't work when you're not owned by the same family. So we're looking at another opportunity to create an income stream. So what you do is you have business owner makes a gift of stock. You can just make a gift of 10% of the total value that you want to sell, or cash gift to the intentionally defective grantor trust. And then the next step is you're going to sell then 90% of what you intend to give away, so stock that you intend to give away, and take back a promissory note. And that promissory note will give you back principal and interest payments over a term of years. You're going to get a low interest rate on that because the interest rates are low right now. So to avoid a gift, it might be a low interest rate. You can do it higher. The interest rate is a minimum, and then you receive that income stream for a term of years. And then this trust, for the benefit of your descendants, which is GST exempt and can be a dynasty trust and live on forever, will own the stock. And so you've got this income stream for a term of years, and then they have the ability to own the stock. It's a grantor trust. It's not a taxable event, not an income taxable event when you do this. and you get those promissory note payments. But what's great about this for a lot of people is that it gives you a little more flexibility than the GRAT, in the sense that while it's a grantor trust, while it's unlike a GRAT where it terminates and goes out to the kids, it stays in a grantor trust even after the promissory note is paid off. And you could swap out cash for that stock or a portion of that stock back if you want to get some of it back. So there's some ability, while it's still a grantor trust, to give you some flexibility. There's no mortality risk like there is on the GRAT side of things, because you've sold the stock for a promissory note. The promissory note would be included in your estate, whatever's remaining outstanding on that promissory note. You can allocate your GST exemption from the get-go because you've made a gift in of the 10%. That's the only thing that you're using to allocate your generation skipping transfer tax exemption. And since you froze the value of the stock at the day you made the sale, any appreciation stays in that trust. It's out of your estate. You have no step up in basis, so they're going to have a carryover there, but you're going to have the ability to swap out the assets. So if it's still a grantor trust, and unfortunately we do not know when death is imminent, right? We don't have that crystal ball. But if mom or dad is not doing well, or we've gotten some bad news, we could take that opportunity to swap out the low basis stock for cash, and then we could put that in mom or dad's estate so that it will get a step up in basis, but you still have shifted the value of that, because when you do that swap, at the time you do it, you have to make sure it's fair market value. It doesn't have some of the benefits that the freeze has, because you can't own life insurance. It doesn't have the same creditor protection. You don't have control or the business governance side, but it's still another great way to provide for an income stream and give you some flexibility to pull those assets back out if you needed to, but you'd have to have cash or marketable securities to swap it in for.
And to try to summarize, when you think about how to manage your taxable estate, Jennifer said it earlier, one size does not fit all. So whether it's a freeze, a GRAT, an IDGIT, the use of dynasty trust, one size does not fit all. Each business is unique, and each business has either already put existing planning in place that might cause limitations on different things, or if we have a green field, the opportunity to do any type of strategy is there. And in addition, we didn't talk much about this, but there's other ways, but we need to create these well in advance to have enough funding. So if we're going to worry about the estate tax and we don't gift everything, or we don't solve it completely that way, there's cash, there's the creation of a sinking fund where you're putting money aside, there's insurance. The last two options are your options of last resort, which is going into debt with the IRS, which I would say is the worst partner you could ever have. And I know Jed is sending these slides out after the fact. We don't really have time to talk about a charitable lead trust, but there is a way to eliminate your estate tax altogether, be philanthropic, and take care of really your grandchildren's children by passing wealth to future generations and getting outside of your estate. So it's a nice technique. And then the last page, we give you a summary so you can kind of compare the three. And last but not least, again, one size does not fit all. And we encourage you to be very deliberate and thoughtful about any planning that takes place and understand all of the intended and potentially unintended consequences of one way versus another way. And Jennifer, I don't know if you have anything else in closing.
No, I think that's great. And I think this summary of techniques is going to be helpful. And again, like we talked about, like Mitch says over and over again, we like all of these techniques. I mean, the GRAT works in certain circumstances, and when you add some more sophisticated planning to it, it really works well. Intentionally defective grantor trust in our case study 3 was superior to the freeze. And of course, we do really like the partnership freeze, because I think in most cases that's going to offer you a lot more flexibility. And it's a business, and you all are already familiar with running a business. You know how to do that. So I think really everybody kind of slowing things down for just a minute and breathing through, oh my gosh, I'm going to lose the exemption if the president changes and Congress gets a change. Take a minute and what makes sense for your family, for your business, for the next generation, and look at these things. What do you want to have happen? And then let's make the plan fit around what works for you. Let's not fit the plan around your business. Let's make the plan work for you.
That all sounds really good. Well, thank you, Mitch. Thank you, Jennifer, so much. Yeah, this is a big pressing point for so many people. They lose a lot of sleep over it. I know Mitch and Jennifer are both available. I'll send out these slides, the recording, as well as their contact information. So if you'd like to shoot them any questions, I know they'd be happy to give you the best answer they can. Again, Mitch, Jennifer, thank you so much. I wish everybody a very good day. Goodbye.
Thanks. Bye.